We'll open the hearing on Senate Bill 434 relative to regulation of public school materials, and I recognize the prime sponsor, Senator Lang.
Thank you, Madam Chair. Thank you, members of the committee. I am Senator Tim Lang from Senate District 2. Again, what you have before you is what I consider, again, a process bill. This bill creates process where if a parent discovers a book in a library that she thinks or he thinks is harmful to minors, which is a definition in statutes under an RSA, which is in the bill. We use a very definitive definition, and it's the whole chapter 571-B:1 is nothing but definitions: harmful to minor, knowingly, sexual conduct, and minor, and a definition of minor. So if a parent believes that it meets the definition as defined by statute, they can just fill out a form and ask that that book be reviewed, in this case by the superintendent. Just review the book, let an educator look at it and decide whether, given the light of the law, if they think the book is harmful to a minor. If it is, the superintendent's able to withdraw the book. If it's not, then it's able to stay. If the book stays and the parent feels that they want to appeal the decision of the superintendent or their designee, they can appeal to the school board. Again, school and education body, local control, allowing the school board to review the book and review the material, and then either concur with the superintendent's decision that it is either is or is not harmful material. Probably the most important thing about this bill is it outlines a process, again, a universal process that all parents, no matter what school district they're in, would be able to follow with a known outcome and known guidelines, how many days it takes, those kind of things, rather than a parent submitting a complaint and it going absolutely nowhere for months on time. This outlines a procedure. Within 10 days of receipt, the superintendent's got to acknowledge it. Within 25 days, he's got to make a determination. And then the parent has a certain window of time to appeal that decision to the school board. And then the school board has a window of time in which they have to act. But it's all known in certain quantities, with one exception. That's at the bottom of page 1. Says the superintendent or designee within the school day, 25 school days of notice of receipt of the complaint or otherwise agreed upon by the parties. So if the parent says, for whatever reason, hey, the superintendent asks and says, I need 2 more weeks, and the parent says that's fine, then that's okay. They can do that. But otherwise, the superintendent would have, unless agreed upon by both parties in this process, the superintendent would have to meet the timelines that are required. So that's the short version of the bill. It's, again, a simple process bill. It allows a parent. So I served, I've said this before, I think, of many a committee. I served on in a school budget committee for 2 terms, served on a school board for two terms. I know that not every school board member, and I know that not every principal knows every book that's in his library or her library, right? And there may be a book that gets through that may have an inappropriate piece to it. I use this discussion, again, I mentioned earlier, I was talking to some kids at a school in a civics and government class, and we were talking about the fact that we were using a rape discussion, right? There was a book, this all stems from a book that had a very graphic rape depiction that was put in a middle school, and it felt it was inappropriate. I was, in my previous life, I was a police officer, and I investigated sexual assault and child sexual assaults. How you talk to a 6th grader is, especially about sexual assault, is completely different than how you talk to a senior or a 40-year-old man or woman that's been subject to a rape. Those are completely different conversations that need to be age appropriate, right? So if a book slips by and is in the 6th grade library that has a horrific depiction of a sexual assault with graphic detail, probably not the right language to use to teach that child about rape. Doesn't mean you can't have the conversation, but not the right language for that age appropriateness in that school. So if a parent finds that, there should be a process, a known process for them to challenge that book and say, can we move this up to the high school instead of having it in the middle school, where it may be more appropriate? That's what this bill does. It just allows for that process to occur and makes it uniform across the state. So every parent of every child in the state of New Hampshire has a known process rather than one that may be different in every single school district. That's it.
Representative Hall?
Thank you, Madam Chair, and thank you for taking my question. You mentioned libraries. Is this strictly about libraries, or is it about school plays, school classrooms?
So let me find the exact section in the bill so I don't misspeak again. So it's in the school itself, anywhere in the school.
I just wanted to make sure that you only spoke about
that's fine.
libraries.
Any other questions? Representative Baldoni?
Thank you, Madam Chair, and thank you for taking my question. So if I read down through anything in the school, this would refer to any printed matter, visual presentation, web-based content, live performance or sound recording, including but not limited to books, magazines, motion picture films or videos, pamphlets, phonographic records, pictures, drawings, photographs, figures, statues, plays, dances, or other representations that are provided by the school district or by school employees, volunteers, guests, or speakers. It's a very broad-based bill. It really affects everything that is going on instructionally and just in the school itself.
So I think we'd agree that if material in any of those categories are deemed to be harmful to a minor, they probably don't belong in our schools. I think we all would agree with that. No. Okay.
Follow up, please. So my question is, in terms of enforcement, so you're saying that a parent can literally challenge for any of these reasons. So if the school has scheduled a guest speaker and has that on the calendar, and procedurally, what is a parent going to come and say, I don't want that guest speaker to come? And then what does the school do? They've already scheduled the speaker. Does that get put on hold? Similarly, if I'm putting on a play and a parent comes in and objects to a scene or just a line in that play, do all these have to go on hold while this procedure makes its way through?
So again, that would all be within the control of the school board or the superintendent, who can act as fast or as slow as they want within the timelines.
Representative Cornell?
Thank you, Madam Speaker. Thank you. Governor Ayotte vetoed 324 last year because of overly broad language, which would open up the district or the state to lawsuits. Could you tell me exactly in your bill what took care of the overly broad language?
So again, I took that to mean that's why I went to a statutory definition of harmful to a minor. The previous bill didn't have that definition. This is a clean definition that's been in state law since 1969 and been used on multiple occasions for various reasons. So again, I took it as to me to make sure it was clear what is the material that could be challenged, which is, again, materials that are harmful to minors, as our definition in statute is harmful to minors.
Representative Perino?
Thank you very much, and thank you, Senator Lang, for taking my question. I just want to clarify. You do not have any specific material in mind with this bill. This is strictly a policy that the school board can enact, correct?
This is a procedural bill, yes. It strictly is a procedure to enact with, this bill's been called the book banning bill. There's not one book banned in this bill. Right? Nowhere. All it does is create a procedure that allows the challenge of material that might be accidentally got through and was inappropriate. I'm not saying there's any malfeasance on anybody's part. The book could have just got through, or the material could have just gotten through, and it was caught by a parent. And so let's create a process for that. Any more than I think a teacher could use this process. If they found a book that they felt was like, wow, this probably doesn't belong in our library, they can go to the superintendent and say, we probably should pull this, right? They process, can exist. So I don't think it doesn't ban a single thing. It just creates a process. So something that might have gotten through that shouldn't have gotten through can be reviewed.
Representative Freeman?
Thank you, Madam Chair. Senator Lang, golly, should we rename this the House Education Policy Administration and the Senator Lang
Committee, apparently it sounds like it for today. I figured it's my first annual meeting of the committee.
He's a genius.
He is a genius. Thank you. Thank you.
Although I do appreciate the chair scheduling all my bills in one day. It makes it much easier.
I do have a question for you, hypothetically, but as a former police officer, you may have an answer to this. So if I, as an adult,
were to provide a minor child who's not related to me by blood or relation with any type of pornographic material, what might the legal ramifications of that be?
So in any other circumstances, you would be charged with the crime.
Thank you.
Representative Woodcock?
Thank you. Just a clarification on Representative Pettinell said that this is enable, and then she went on to discuss what that was. This is not an aid. Do you see this as enabling legislation?
No, so to her point, it has, it's a mandate. It's an outright mandate on the process. But what I will say is that these are not the only conditions that, if you read on, let me find the line. So line 16, at a minimum, the complaint resolution process shall provide, right? So the school board has flexibility to change, but we set some minimum standards on dates and times that they can do. If they want to make it, instead of 10 days, want to make it 7 days, that's completely within their right, but at a minimum, it has to, you can't go beyond 10.
Follow up? Thank you. I do agree with you, Senator Lang, which probably not often, but I do agree with you on your age appropriateness. I think that the case you made about the rape definition or however that book or show, however it came in middle school, probably isn't appropriate. I would concur with that. But I do have, using that same criteria, I do have concerns that things at a high school may be age appropriate. They may be a minor in terms of 18 years old, but the discussion could very well be age appropriate. Or the theater performance could be age appropriate. Or the guest speakers may come in and have very, on both sides of the discussion, whatever the issue happens to be age appropriate because the 17, 18, 19-year-old, 17, 18-year-olds, 16, 17-year-olds, kids in the senior year of high school. So I find this, the bill, age appropriate, I don't see there, but I hear what you're saying. But I do have concern that things at the high school particularly, that out of place would seem incorrect. But different pieces of work, different guests, different visitors, the discussion that they bring to the table for students to talk about afterwards, providing their point of view. I think this really limits the opportunity for schools to allow students to be exposed to things that are age appropriate, but under 18.
So thank you for the question. So again, if you look at line 15 in the bill on page 1,
Yeah.
and again, is a material that is harmful to minors, age inappropriate, right? So is one of the challenge points. So again, I want to remind everybody, educators are making this decision. This is not us making this decision. This is the superintendent of the school and the school board are making that decision. This is not anybody else making the decision. So if an educator thinks that a book is age inappropriate, it'll be removed. If an educator thinks it's not, it won't. This still gives the power to the education system. It is not us absorbing process. It just gives the parents a known process.
One last question. Thank you. It goes back to the concept of minor. Minor. I see an age appropriate after the comma, but it goes back to the process of minor. We're using the age of 18 as a minor or 17 as a minor, harmful to minors. So that's the part that becomes difficult, and I do think it does limit the opportunity for instruction and conversation, particularly at the high school level. But it does say, I understand inappropriate offense, I get that, but you precede that with harmful to minors, and minors is a definition by age. So that's the part I see with that concerns me, as well as going back to the disruption that makes, I understand this is a process that's afterwards, but if a school play started in the county, does that mean every school play has to be approved prior to being played by the superintendent?
Well, I believe they already are.
It would be after their complaint. It goes back to, I think, Representative Balboni's issue. It goes back to after the kids come home and here's my script and I get selected for the play and oh my God, the parents are, you have to say that? And then it's the wheels stop. Then they go to school and then they complain. Now this is the 17-year-old, senior in high school. Oh my goodness. And everything stops until you go through this process. So it really is disruptive. I understand the goodness of this, but it's really disruptive and I think impinges on public education for the good of education for kids who are age appropriate, but maybe legally minors. Thank you.
any other questions? Representative Balboni.
Thank you, Madam Chair, and thank you again for taking my question. In terms of the process, I'm going back to a single complaint. So one parent.
I'm sorry, where are you on the bill?
I'm just talking in general about a parent makes a complaint, and I am a superintendent, and I have 7 towns in my district. The complaint comes from one school. Now I make a decision, and my decision is that it's fine, or if my decision is that it's not, does that translate into, now the superintendent has all of those towns, does that decision apply to all of those schools within that superintendent's purview?
So again, the superintendent is the superintendent for the district. If the district's made a determination the book's inappropriate, and in the district, the book's inappropriate. So what I will say is originally I had this as principal, and the Senate Education Committee changed it. I had it the principal because I thought the principal would be the most age appropriate, a person who knows the age range and be able to identify books based on age best. And I had it at the principal, but the Senate Education Committee chose to move that to superintendent, and I believe they did it because of the potential legal consequences, and that somebody other than a principal should look at it.
Follow up, please. Follow up. Follow up is also, what would happen if the complaint was denied? It went through, the school board denied it, everything went through. How long is that decision good for? I mean, say a parent decides, for that year, and you've got another parent come in the next year and makes the same complaint.
So again, it goes back to the definition of harmful to minor in our statute. If a book is harmful to a minor, it's not time specific, right? So if it's harmful to a minor, again, someone asked me about if I gave a pornography to a child, it doesn't matter if I did it this year or next year, it's still going to be pornography and it's going to be inappropriate. I'm still going to be charged with the crime, right? So again, I don't think in any circumstance, once a book's been determined to be harmful of a minor, we should then put it in the hands of minor.
Excuse me, you misunderstood my question.
Okay.
If the superintendent had decided that it is not, and then another parent, however, like a month later, brings the same exact complaint, it's already been determined by the superintendent that it is not, fits that statute. I mean, could conceivably another complaint come the next month or the next year, or how often are these complaints going to come up? There's nothing in this bill that addresses repeat complaints about the same materials.
You're absolutely right. There isn't none any more than is anything in statute that does multiple complaints against teachers. The superintendent's going to take every complaint against a teacher. Just because I already have a complaint and some other student comes in and files a complaint doesn't mean I'm going to ignore the second complaint. The teachers, they're going to take every complaint on its merits.
Representative Selig?
Thank you, and thank you for taking my question. I think about a book that was used with my children when they were in elementary school, called The Only One Club. And it was a lovely story about how a child felt like they were the only one of something. And then through the course of the book, they learned that everybody in the class is the only one of something. Every single child has something that they're the only one of. And in the end, they make little badges for everybody, including the teacher, because she's the only teacher in the room. It's a very sweet story about how to be inclusive of everyone. So the book, I think at one point, one of the children's uniqueness is that they're the only one with 2 moms, and someone else's is that they're the only one with 6 brothers, and someone else's is they're the only one of a particular religion. So if a parent who objects to people having 6 children or objects to religions or whatever comes in and files a complaint through this process saying that they believe that book is inappropriate for kindergarten and first graders, for whatever reasons they claim it's harmful to minors to hear these thoughts. And so it goes through the process, and the superintendent decides this book is fine. It's not doing any of those things. And they continue to go through the process. Where does the level of complaining stop? So if we have 5 other parents who come in and make literally the same complaint where it's already been determined, and this is again reflects Representative Balboni's question, how many does it, because now we've got 5 parents who say, I don't like this book, does it have to change the superintendent's position? Or if the superintendent has ruled this book is fine, can we just say this book has already been ruled and we don't need to go through any of this process again? We're wasting time, we're wasting money, we're wasting resources on
I would not suggest that at all, that you should waive any future complaints on the book. if they've already done the study, then it's literally just repurposing the letter that you previously did and say, this book's been reviewed and here was my finding. I don't think that's an objection, but I think that a parent has the right to make the complaint and to have a process in the process of the complaint. You should not tell a parent you don't have a right to make the complaint.
Yes, good. Another question?
Sure.
Okay, thank you. So on a related note, you talked about a book depicting rape and being available at a middle school level. And I agree that there's different ways to talk about sexual assault and other kinds of things. And I know that organizations like Haven have designed programs where they come in and talk with children, starting at the preschool level, about what are safe touches and what are uncomfortable touches and whatnot, so that children are able to identify if things are happening that they may not be aware is not appropriate. And so at what age is it acceptable for children to be able to see a book in their library that reflects potentially a traumatic experience they've had, that they can say, wait, that happened to me, that shouldn't happen to me, or wait, that happened to me, maybe I'm not the only one that's happened to, and to feel safe to talk with someone about it? Where's the minimum age for them to be able to have that experience?
So again, it goes back to the discussion. I put educators in charge of making those determinations because they deal with children, right? That doesn't mean you ignore the complaint. It means that an educator whose job is to work with children should know what the right, in my conversation, going back to my sexual assault conversation about how you talk to different kids. An educator's going to know that, just like I knew as a police officer after being trained by the FBI. How you talk to different people is different, and how the words you use for the same exact act is completely different, but it's age appropriate. So we put an educator in charge of making that determination on whether this book has value or not, and is appropriate for that age range. We didn't put the legislature, we didn't put the court system in charge. We put the educators in charge.
Representative Litchfield?
Thank you, Madam Chair, and thank you, Senator Ling, for taking my question. We've heard several times now what happens if a complaint is brought about this with the same book or the same type of material several times over. Would you say that if a complaint continues to come up about the same materials and it's several different parents, that maybe it's time to take another look or some time for self-reflection?
Absolutely. Again, the perspective is everything. And so after 5 complaints, you may go, maybe I missed something, and you want to review the book again. That's going to stop a principal from doing that if they choose to, right? If they continue to get complaints about a given book. They may want to review that again and say, somehow I didn't see the perspective that the parent's talking about. Maybe review it again and look in that perspective. So nothing stops them from doing that either.
Representative Terry?
Yes, thank you. I want to come at this from a different direction. Without such a clearly defined process that would be statewide, so it would apply to everybody, that's as clear-cut, 2-step process where the arbiters are, as you say, the educators, the superintendent, and then ultimately the school board, and then in the final analysis, the parent, if the parent isn't satisfied with the decision of the superintendent and the school board, because then the parent can withdraw the student from the school or can go political and try to change the makeup of the school board, which has happened all across the country.
With any luck, they go to open
so
enrollment.
where are we left if we don't have such a clearly defined process as outlined in this bill? What kind of chaos are we left in?
Well, again, you end up in an ambiguous, vague stage where you can't make determinations, right? There's no clear, and what happens in one school district completely different in another school district. So again, I think the whole purpose of this is not to ban any one book and say, I think this book's bad. It's strictly to create a uniform process that every parent gets treated the same in the state of New Hampshire in how, if they have a concern about a book, and how that concern is addressed. They'd have a uniform process no matter what district you live in. They'd have a uniform process.
Follow-up?
So in a sense, what I'm hearing you describe is actually an ultimate remedial process. to address a situation or situations across the state where there's uncertainty and ambiguity and perhaps arbitrariness?
Sure. So again, the issue is, I use that definition of harmful to a minor for a reason, is because it establishes state standards, so that the standards used in one district for determining this, it's harmful to a minor or something other form, like it's not pornography, so we're okay with it. That's the only determination they make, is on that one classification. It allows for a standard practice so that it's evenly handled in every school district.
Representative Selig?
Sorry, thank you. To follow up on Representative Terry's question, we already have a process by which parents can appeal to a school district if they oppose a book, and also opt their child out of reading any particular book or any particular lesson. Is that correct?
Some districts have that process, not every district.
Every parent can opt their
Every
child
parent can
out.
opt out. You're right on that. On a given, in a library, you can say, I don't want my child to check out this
So
book.
the difference would be that this bill would allow one parent who might have a specific agenda to opt every child out of reading some other material that they personally objected to. Is that correct?
So again, the only way that would happen is if they objected to the book and then the superintendent agreed with the parent's objection, which means that they agreed it was harmful to a minor. And again, I think we said, I don't think we want to put materials harmful to a minor in minors' hands.
So one parent could object to a book for an entire district and take the other parent's choice away. Is that correct?
Again, no, that's a mischaracterization. One parent can object to the book, you're absolutely right, but then an educator makes the determination on whether that meets the criteria necessary. Again, is that material harmful to a minor? An educator makes that decision. So it's the school deciding, yeah, this parent's right, or no, this parent's wrong. The school makes that decision, not the parent at all. The parent just makes the right to challenge, but the result of that challenge is completely within the hands of the educator.
Representative Woodcock?
Thank you. I was interested in Representative Perry's opportunity to pitch, but my concern comes the difference between local school boards, urban school boards, rural school boards. Clearly, a school board in a very rural area may have a different thinking than one in a very Concordish area. Okay. So I'm trying to, and I understand your desire, I think, of having one system for everyone. But I wonder why we would do that when we allow every local school board that understands their community and has representatives and educators from their community, let the local school board make the local decisions on what is inappropriate in their building or what film is appropriate versus making it one size fits all.
So again, a little bit misrepresentation. The definition is harmful to a minor, right? That's the definition. And we're not defining what that is. We're saying harmful to a minor and leaving it to the educator to decide whether or not that criteria is met. So again, and if they decide it's not, then the book doesn't get removed. If they decide it is, the book gets removed. Again, the educator, the superintendent makes the determination, not anybody else.
Just a clarification. Yeah, it's clarification. Yeah, but the question, Senator Lang, is why wouldn't we allow local schools to make their own decision? Why do we have to have one size fits all in this process? When local school boards have been elected, hire a superintendent, hire teachers, and have, as Representative Selig say, have processes, have policies on complaints and all these things. I guess I'm concerned we continue to take things, one time we say, well, one size fits all, and then we say, oh, we can't have one size fits all. I just wonder why we don't allow something as close to important to a local community to let the local community handle it.
If you can give me a case where a local community can decide to give pornography to a minor, I'll be happy to listen to that argument, because I don't think there is one, right? And so this makes it clear that there isn't a case to do that.
You said this is process. We understand what a minority or what a minor is. We talked about the age issue and being age appropriate. But this is about process. Why? I'm not suggesting that, don't play those words. What I'm suggesting is the local community can make that decision, not what a minor is, but what is inappropriate. But you've taken that out of this. I just want to say why I don't leave that in the local school board, that's all.
I don't know if I can answer it any clearer. This is a process bill that creates a process so all parents are treated the same across the entire state. So there's no differentiation between that. The definition and decision is made by the local school superintendent, not, so it is still local control. It's in their determination of whether or not it meets the criteria.
No, it's not local control if you outline the process. Don't show the process there. Thank you.
Any other questions? Representative Balboni.
Thank you, Madam Chair. Just one clarification. You mentioned several times that it only is for material that is determined to be harmful to minors. I just want to address in lines 13 through 16, it actually says that they can bring complaints alleging that material is harmful to minors, age inappropriate, or otherwise offensive or inappropriate for use in the child's school. So it is more expansive than just the harmful to minors statute.
Right. Again, but I think any of those other categories are just as damaging.
Representative Hall?
Thank you. Just a quick question. Thank you, Senator. Can you confirm that parents are treated differently in the process throughout the state?
I can tell you that not every school district has the same policy as it relates to how to challenge a book. So therefore, that in and of itself would mean that each parents in different districts are treated differently.
Thank you. Any other questions? Seeing none, thank you very much. And we will go to 3-minute testimony. Rachel?
Thank you so much, Madam Chair and members of the committee. My name is Rachel Potter, and I'm here as Policy Associate for the ACLU of New Hampshire to oppose this legislation. And really for a simple reason, because this legislation is a book ban. And banning books violates the First Amendment, threatens our democracy, and frankly is just not the New Hampshire way. Free access to ideas is foundational to a healthy democracy, and suppressing ideas prevents open debate and informed citizenship. This bill raises serious constitutional, educational, and just plain practical concerns, some of which were pointed out in the questions here before. This bill would be one of, if not the most expansive book ban in the country, allowing for removal of a host of classroom materials, as we've talked about, based on vague and subjective standards, such as what may be considered offensive or age inappropriate. Public schools are not spaces for ideological conformity. They are meant to prepare students for participation in a diverse and complex society, and that requires exposure to a wide range of viewpoints, including those that may challenge or expand a student's perspective. And the Supreme Court has recognized that students don't shed their First Amendment rights at the schoolhouse gate, and that includes the right to receive information. And SB434 raises particularly serious concerns because it invites viewpoint discrimination. Across the country, similar laws have disproportionately resulted in the removal of materials that address race, religion, different religious texts, gender, LGBTQ plus identities, and other historically marginalized perspectives. When a law enables the removal of materials based on disagreement with their content or viewpoint, it crosses that constitutional line. And this bill is also just plainly unnecessary. As we've talked about, schools already have processes in place for parents to raise concerns about materials and for parents to opt out of any materials and for their families to make decisions for their own children without restricting access for somebody else's children. SB 434 goes far beyond that. It allows one person to limit what all students can learn. And that's not parental choice. That's a person's preference becoming a rule for everyone. And that preference can go any way that the cultural tide turns. And that's not the live free or die spirit. And this creates a chilling effect in classrooms. The result is not better education. It is less honest, less rigorous, and less effective education. The vague standards in this bill will lead to inconsistent application across districts, as we've kind of explored in the questions before this, and invite costly legal challenges. And not to mention the wide breadth of materials potentially covered by this legislation will make it nearly impossible for local districts to manage. Courts have repeatedly scrutinized these laws that restrict access to ideas in schools, particularly when they're vague and enable viewpoint-based removal. And so for those reasons, we ask you to oppose it.
Thank you. Are there any questions? Representative Woodcock.
Thank you. Welcome back, Attorney. Can you define, Representative Balboni brought this up and I don't see a definition. I'm looking at the bill, I don't have a copy in front of you. On line 15, what is otherwise offensive? How do you define that?
I don't have a copy of the bill in front of me, but I know that otherwise offensive is a term that we would consider very vague and a subjective standard. And so that's what creates a lot of the constitutional concern with this law.
Okay, thank you. Thank you, Madam Chair.
Any other questions? Representative Okay, Representative Cornell.
Thank you. Thank you. I know that Governor Ayotte vetoed this and that this is in response to trying to make it less vague. Do you see anything in this bill that would make it more likely to get past the veto than the other one?
I can't speak to how the governor is going to react to this bill, but I will say that we view the bill as unconstitutional, as one of the most, if not the most expansive book ban in the country. So we will let her know that.
Thank you.
Representative Freeman.
Thank you, Madam Chair, and thank you for taking my questions. I'm going to ask you the same question I asked Senator Lang. If I, as an adult, were to provide a minor child who's not related to me by blood or relation with pornography, what might the legal ramifications be?
I'm not seeing how that is related to this specific legislation. So
you don't have an answer for my question.
Rephrase it, I guess.
Pretty simple. What would happen to me? What would happen to me as an adult if I provided pornographic material to a minor child who's not related to me by blood or relation? What would happen to me?
Again, I'm not seeing how that's related to this book banning bill.
Thank you.
Would you believe that there's actually pornography in the public school libraries?
I haven't been to every public school library, but I know that there are processes in
I
place.
have a really good sample right here, and it is pornography.
So there are
And
processes.
no, a child does not have a right.
Point of order.
No.
I'm going to finish. A child doesn't have a right to read pornography. Are there any other questions? Representative Selig.
Thank you for taking my question. Thank you for taking my question. Sure. So I'm looking at the section where it talks about pamphlets, phonographic records. Sorry, I have to, after the last conversation, reread that. Pictures, drawings, photographs, figures, statues, et cetera, et cetera, et cetera. So I think about the art classes that are taught in our schools, which include teaching people how to draw people, where they use those like little wooden thingies and other kinds of things, and they don't bring people in to, stand there unclothed as they might in a college setting. But they also do take kids to museums where they would see perhaps the statue of David. Is the way this law is written, does this mean that I wouldn't, as a teacher, I'd be subject to risk for taking my children to a museum? And maybe I'm taking them to see something else, but there happens to be nudes in the museum? Is that...
I would say
teacher putting me at risk?
Sorry to interrupt you. Yeah, I would say that it's vague enough that we would be concerned for the chilling effect that it would have on teachers. I can't speak to that specific scenario because it is so vague. But yes, the bill encompasses a wide variety of materials beyond books, as we've talked about, performances, art, and so just the mere, enforcement aspect itself is just nearly impossible and impractical.
Thank you.
Any other questions? Representative Litchfield?
Thank you, Madam Chair, and thank you for taking my question. Sure. You've mentioned several times the phrase book banning, and I wanted to ask you, I've gone through it a couple times, where in this bill do you see language that would result in banning books rather than establishing a review process?
Sure. So this bill would, for the third year in a row, provide avenues for banning books that are fundamentally unconstitutional and a violation of our First Amendment rights and students' freedom to read. would be my response to that.
So,
Representative Terry?
so you would have, with respect to Representative Litchfield's question, so you would have an issue with a decision made by a superintendent and a school board to uphold a parent's objection with respect to content. You would have an objection to that process and those parties involved making a local decision somewhat consistent with the Supreme Court's rulings about community standards?
So the way that the bill is written is so vague, and school districts already have processes in place. Parents can already opt their children out of any materials, so.
Excuse me, that's not my question. My question is, you would object to a superintendent and a school board making a decision?
The way that this bill is worded, yes. The process that this bill lays out.
Any other questions? Representative Selig?
Thank you. If a school board and a superintendent determined a book was not appropriate for their community and withdrew it because the school board and the superintendent decided it was inappropriate, regardless of this bill, that would be totally fine, correct?
I mean, I think it's a case-by-case basis as far as if you're talking about a specific case, but the processes that are already in place, this is happening and it already happens, and this specific legislation is what I'm here to oppose today, not a hypothetical.
Any other questions? Representative McDonald?
Thank you, Madam Chair, and thank you for being here again. I know we've discussed this at length in other proceedings. I am curious, you referenced that there are policies in place in some districts. Do you have an example of a model policy that's working?
I do not at the moment. I defer to some other folks here that might be testifying and might have more to say on that, but yeah.
Any other questions? Seeing none, thank you very much.
Thank you.
David Trumbull? That would be better as well. Pay attention. No, can
Thank you, Madam Chairwoman and committee members. I'm David Trumbull from the town of Ware, and I oppose this bill. Essentially, we have two options. The status quo right now, every school district has some sort of process to deal with complaints, and a parent who's not satisfied can opt their children out. This bill replaces the I will opt my child out with I will opt out the whole classroom and the whole school if I object to issues. To try and answer some of the questions, is there a model bill? I believe there is. The American Library Association has processes for these sorts of complaints. There was a bill, in fact, proposed in the legislature to use the American Library Association model. That would have been a pure process bill. It would have said, here's how we do it. This bill is not a pure process bill. It's a content bill. It takes the phrase harmful to minors, but then it becomes a change in content when it adds the other criteria, the otherwise offensive or inappropriate. Those are vague terms. How do you determine what is otherwise offensive or inappropriate? This bill does change the results that would be made by school boards, to answer Representative Terry's questions, because it now expands what can be banned from simply what is harmful to a minor to anything that's offensive or inappropriate. To go back to the First Amendment issue, I'd like to just go back to that U.S. Supreme Court case, Board of Education versus PICO. They said the First Amendment applies to the school setting, and they said the Constitution protects the right to receive information and ideas. The right of freedom of speech and press embraces the right to distribute literature and necessarily protects the right to receive it. The children in the schools have the right under the First Amendment to receive information. And if we deny them that, then we are not doing our job to properly educate them. And one example that comes to mind is that 75% of books that are sought to be banned involve a character who is either a person of color or LGBTQ. So take an example of a book where there's a character who has parents who are in a same-sex marriage. Some people will find that otherwise offensive or inappropriate, and they will complain to the school board. Other people who may be legally, constitutionally protected married as same-sex couples will say, well, that's not otherwise appropriate and offensive. That's my family. But this bill would allow banning those books, and that's 75% of the book bans in this country. So I don't think we should allow one family to censor books for other people. This is not a process bill. It's a content bill. It expands the cases in which books can be banned. I think the status quo is a lot better. Every single school board has got some sort of process to deal with it right now. They do it. They make sure there aren't books harmful to minors. We should not expand that to include books that one family might find offensive or inappropriate. I think that's all I have. Thank you.
Thank you. Are there any questions? Representative Freeman?
Thank you, Madam Chair, and thank you for taking my question. So I'm curious, do you have a list of those 75% books that have been banned? I'd like to see that list.
So that research is from, I believe, I didn't bring my whole file with me, but I think it's from the American Library. Oh, no, wait a minute. There's a group that does a report every year on the books that have been banned. And that's the statistic. 75% of books, it's either a character who's a person of color or LGBTQ. Those are the books that are constantly brought forward for book bans.
Follow up? Thank you. I'd really like to be supplied with that reference. I'd like to see what that 75% of books that are banned is. I think that's important for us to have context on what we're looking at. May I have a follow-up, Madam Chair?
Sure.
Thank you. And you also referenced books that were banned, and I'm pretty sure you said 75% of them had content with people of color. Is that correct?
No,
I'm getting that wrong?
Okay, thank you for the question, Representative Freeman. What I said was that 75% of books that are sought to be banned involve the character who is either a person of color or LGBTQ.
Okay, if I could get that, I would be much appreciative.
I bet you before we get 5 minutes past this, somebody will have Googled it and be able to tell you the name of it. I'm embarrassed. I don't remember. It's a group that studies libraries. It's been at it for 100 years. They've been doing this.
I'm a patient individual, sir. If you can get that to me at a later date, again, I'd be much appreciative.
Absolutely. I'll do that, Representative Freeman.
Any other questions? Representative Litchfield.
Thank you, Madam Chair. Thank you for taking my question. Can you please just help me understand what you're saying when you say, what is your definition of banned? Because I'm wondering if we're talking about books that may have been challenged due to inappropriate or objectionable material within the book, or outright banned. And when you say banned, what does that mean? Like, do you mean banned across the state? Do you mean banned within a local preschool? Like, where does this come from?
I think that this bill creates it does two things. It creates a uniform process for these cases around the state. And then what it does is it expands the criteria under which a book or any of these other materials, plays, and so forth, can be banned in a school or in a school district.
Excuse me, I'm sorry. I meant to, maybe you misunderstood. I was basing it on the statistics that you just gave, not the interpretation of the bill.
Oh, okay. I'm sorry. I will send it to both of you. I'll send it to the whole committee. It's sitting in front of my mind. I can see it. But anyways, there's a group that defends freedom of the press, and they've been looking at book bans for over 100 years, and they do a report every year. And this is the general statistic, is that 3 out of 4 times when there's a book or something to be banned, it involves characters who are either people of color or LGBTQ. That's in recent years, obviously.
Follow-up?
Yes, I would like to ask you to please take it a step further in your research. Understand what you're saying about LGBTQ characters, and that would not be okay. I would like to just have it clarified in these books. Are there discussion of different sexual situations, and are they graphic, and are there pictures? Thank you.
I understand your question. And this goes to the age appropriate and graphic sex. And the definition of harmful to minors refers to this other statute, which it's 571B11, which lists 3 things: sexual conduct, but also this other section called lacks serious literary, artistic, political, or scientific value. those cases, when they go to court, look at these books or materials when taken as a whole. So even if we use this standard, okay, there will be books that taken as a whole will be deemed to have literary or artistic value, although they may have a section in them that would be offensive. And so that would be under the definition that Senator Lang used. He said, we'll use harmful to minors. It's been around for 60 years. That language has been used at the federal level, U.S. Supreme Court. And it references this section, this harmful to minors, says sexual conduct or lacks serious literary, artistic, political, or scientific value. If you Google lacks literary, scientific, artistic value, it'll say those cases, when the courts look at them, they look at the book as a whole. And so even though there may be sections in there that would be offensive, the book would still have artistic, whole literary value. Classic books sometimes have sections that might be. So I guess what I'm saying is then that's up for a school board to determine that book maybe belongs in the high school library, but not in the middle school library. We have a process for that right now. We don't need a bill that expands the categories of cases that can be banned to anything that's offensive or inappropriate, because that's not defined. Senator Lang said, my bill is just a process bill. I'm using a definition that's in another statute, a definition we've had for 60 years. And then he was asked, well, what about the fact that your bill expands it to not just use that definition, but be anything that's offensive or inappropriate? And he says, oh, I'm going to get it right. He was asked that question. He said, I think those things are bad too. Essentially, I was taking notes on how he answered that question.
Any other questions, Representative Terry?
Yes. With respect to your stated objection to the expansion of the number of categories under which a parent can object, is there really any difference in the final analysis as to who makes the decision, the superintendent and ultimately the school board? So that, to be real clear about this, a school board could say, we don't believe that this book is otherwise offensive. We don't believe that this is otherwise inappropriate, even though it might be an expansion of the categories. Nevertheless, it is the school board that decides what materials are going to be made available and what materials are not going to be made available. So what's the issue?
That's exactly the reason why so many of us are here objecting to this bill. You seem to be in favor of letting the school board make that decision. And I would agree with you. Let the school board make that decision. We trust them to make that decision now. Every school board in the state has a way of dealing with this right now. So they have criteria. They go through it. That's fine. If you want just a process bill, if you want to have the same process, the same number, you complain to this person, you appeal to that person, you have so many days to do it, then make that the bill, right? Take out all of this expansion of what can be banned in this bill. If you just want a process bill, then just do a process bill. This bill is a process bill that's uniform, plus it expands what can be banned, and that's where the objection lies.
So you would be happy with every school board making its own decision as to what its policy is going to be and what materials are going to be, would be considered as categories under which a material might be removed, as opposed to a universal list of possibilities that ultimately the school board is going to decide whether they agree or don't agree.
I don't have a disagreement with you.
Is it that? It's you don't want a statewide definition of the list? Because you're not, it seems to me you're not objecting to the process. I'm not hearing that so much as it is you're objecting to the list. And you want the school boards to have the freedom to be able to decide their own lists rather than to have a universal list from which to choose.
Thank you. So
Yes.
a couple things. Thank you for the question. So as far as process goes, I'm not opposed to a uniform process. As I said, the American Library Association has a model that they've proposed. I remember hearing testimony from the Dover School Board about this, that they had a bill and they went through this process and they created a process which they are now offering to other school boards in the state as a model. So I think it's a good idea to have a model, because this is something the school boards, they have a lot of other things that they have to deal with. So a fine process, I think we're in rough agreement. As far as what should be the decision-making factors, what they should use to decide, I think that should be largely within local control. But this bill goes beyond that and it expands what can be banned to anything that's offensive or inappropriate. That's just so broad that it's hard to imagine something that many people would find things offensive or inappropriate. I gave the example of a book where it's about a child, and it's a children's book, okay? The child has two parents, they're same-sex parents. That's a constitutional right. But some people are going to say, that's offensive. I don't want that book, my child reading that book. Right now, they can opt their child out of that lesson. But I don't think we should take that book out of the school library. We shouldn't take it so that we just dismiss that as an idea that we're willing to discuss.
So I appreciate your opinion, and I appreciate there are different points of view as to what ought to be available and what ought not to be available. But in the final analysis, it becomes every school board, beyond the superintendent, if there's an appeal of a decision that is made by a superintendent that the parent doesn't like. Ultimately, it's the school board that decides whether or not material is going to continue to be made available or not be made available. And it doesn't matter whether the list has 3 items on it or 3,000. To be extreme here, the school board decides. And if the parent doesn't approve or doesn't like the decision, then the parent has other recourses, such as I withdraw my student from the school, or I decide I'm going to run a slate of candidates to the school board who agree with my opinion, and maybe we win or maybe we don't, which is America, right?
Right.
So it's the school board that decides.
Okay, thank you, Representative Terry. I appreciate where you're coming from. You're saying ultimately the school board's going to decide whether or not the list of things they can use is either just harmful to minors or harmful to minors and otherwise offensive or inappropriate. Either way, the school board's going to make the same decision. So why do we care if it's in the bill or not? Is that essentially what you're saying?
I'm trying to drill down on how it is that you're objecting to an expansive list of possibilities from which a school board chooses, because a school board doesn't have to make a decision that may be in agreement with the parent's point of view. The school board could, in extremis here, the school board can say, we've got all kinds of pornographic material in the school. We don't consider it pornographic. We've got all kinds of material here that that this parent objects to, but we don't believe that it's harmful at all. We believe it's beneficial to students, and so that's the decision of our school board until some other group makes a decision to the contrary.
I understand where you're going. So right. I would look at it this way. It's like concentric circles. The core circle is harmful to minors. Okay, those are the books that right now they're banning and they would continue under this. This bill expands that concentric circle out wider and now includes offensive or inappropriate. And you're saying, well, who cares, because the school board's going to either rule one way or the other anyway. And what I would say is that, go back to the First Amendment, there is inherent value in children learning and having open schools where children can be educated. They have a First Amendment right to receive information. So if we have a law on the books that says a school district could ban books just because somebody thinks it's offensive, I think that goes against the First Amendment. So I don't think that should be in the law. If we both could agree that something that somebody might find offensive, even if it's a constitutional right, but somebody would ban that, that's bad. So I would say let's not put bad things into law. If you want to go to that narrow concentric circle of things that you find very offensive or harmful to minors under that statute, that's one thing. But when you expand it out to something that anybody might find offensive or inappropriate, we're now potentially making it legal to ban something that somebody just might find offensive. That's taking away the First Amendment rights of everybody else in that school. I don't know if I've answered it, but I appreciate.
You've answered the question, and that's why you're here. Thank you.
Thank you.
Representative Woodcock?
Hey, Mr. Trumbull, I think the organization you were looking for was PEN America.
That's it. Thank you very much, Representative Woodcock. PEN America.
Poets, essayists, and novelists.
Representative Selly?
Thank you, and thank you for taking my question. I'm thinking one of the many bills, and I don't remember where this one is in process, would have us consolidate so we have one superintendent per county. but that doesn't change the school districts and school boards that are local. So if I have one superintendent per county, and I'm in this town with my school board here that reports up, or I don't even know how that's all going to work, but which school board do I appeal to? If I disagree with my superintendent, do I appeal just to my school board, or do I appeal to the other school boards he also reports to? And what if the two different school boards disagree? And
It's kind of an extreme hypothetical. That bill is no longer.
did we kill that bill? I'm sorry.
Yes.
Okay, well then I was just trying to figure out.
Mercifully.
Okay, then I withdraw my question. I just was thinking about that bill and how would that possibly work with all of this? So, okay, well, I guess it's another reason it's good we killed that bill.
Any other questions? Seeing none, thank you very much.
Thank you.
I was going to start drinking.
Okay, this next one, it's either
Teetotal alcoholic with
Willow or Wilbur. Willow, okay. That's right the first time.
I'm sorry?
Honorable members of the committee, my name is Willow Earth. I live in Derry and I oppose this bill. What books should and should not be read by children should be the decision of the guardians and the educators. Is this really the live free or die state if any one individual can censor books out of personal grievance? We should be focused on raising kids to think critically, not restricting their access to educational knowledge. Please vote against this bill. Thank you.
Thank you. Do you want to take any questions?
Sure.
Are there any questions? Representative Woodcock.
I don't have a question. That's what he's been sitting here all morning. Thank him for that one line, waiting 3 hours to say that. Thank you.
Okay, thank you very much.
Thanks.
Jacqueline Benson.
I had written down good morning in my testimony here, so good afternoon, members of the committee. My name is Jacqueline Benson. I'm the New Hampshire Regional Leader for Authors Against Book Bans. So I'm here representing about 36 authors, editors, and illustrators resident here in New Hampshire who share deep concerns about this legislation. Senator Ling described this as a process bill, but we already have a process in place for addressing the provision of harmful material to minors. That's RSA 571. We already have a process in place for parental objections to their specific children being exposed to material that they otherwise, for potentially very broad reasons, find offensive or disagree with. That's RSA 189. So there's a question to me about what the value of this bill is with those processes already in place. As some of the other speakers have pointed out, what this bill does that goes beyond that other legislation is it broadly expands the books that can be banned using this otherwise offensive or inappropriate language. And what I wanted to kind of make sure the committee is aware of here, Authors Against Book Bans, several of our members outside of New Hampshire, well, and one of them is actually a prominent New Hampshire author, are involved in lawsuits that have been brought against bills with similarly broad definitions for the books that can be removed under their legislation. There's a case in Florida right now that has already had one ruling in favor of the plaintiffs where they have said that this law is unconstitutional. That's currently being appealed. There's a case in, let me see, there's the Iowa case. That one is now under injunction. There's another one in Idaho. In Utah, there is a lawsuit that just got filed because a book was removed from the state. So in Utah, under their law, if a book is banned in 3 schools, it gets taken out of all state schools. And a book from written by Kurt Vonnegut was removed. And so Vonnegut's estate is suing. So even dead authors can sue you over this stuff. And this was one of the points that Governor Ayotte made in her veto of SB434, is that as this law is written, and as some of the other speakers have pointed out, you are potentially running afoul of constitutional protections for freedom of speech and exposing the state of New Hampshire to legal action. Some of the parties involved in these lawsuits, beyond the authors, you have the big publishers like Penguin Random House and Macmillan. These guys have deep pockets. you're looking at very expensive liability for the state. As Mr. Turnbull pointed out, there is other legislation, there's other model legislation that the state could consider if we want to address this at the state level and not at the local level where it's currently being addressed. The American Library Association recommendations on this are much more constitutionally robust. There's still a strong vehicle for concerned parents to raise issues about books that they are worried about, but you would be more protected from that potential liability.
Thank you. Are there any questions? Representative Dry.
Thank you. Thank you, and thank you for taking my question. Daughter of librarian.
Hi.
I don't know what your idea of band is. Mine, I think, is larger than yours.
Okay.
Okay, as in band is not available. That's it. And I don't see where these books are not available otherwise if they're removed from a particular library.
So your argument would be if they're taken out of the library, they're not banned because potentially somebody could just go buy the book at a bookstore, for example.
That is correct. Thank you.
I would counter that with the point that our libraries are established so that knowledge, information, and stories are available to everyone in our communities, regardless of their ability to go to a bookstore and pay for books that they can't otherwise find. So in removing books from the library, you are eliminating access for certain groups of people that may not otherwise have the resources to go and buy these books elsewhere.
Representative Litchfield?
Thank you. And thank you for taking my question. This book that is not allowed in what began as 3 schools in Utah, are you aware of what the book is?
It was a Vonnegut title. I don't remember which one off the top of my head.
I didn't mean it. Sorry, it's not a trick question. It's Slaughterhouse 5.
Okay.
And when I'm looking it up, I just wanted to get more information about the controversy. But did you know that the controversy surrounding the book stems from graphic depictions of war, themes of fatalism, and the inclusion of strong language and sexual content?
Yes.
Which is why it's been challenged. So would that not lead us back to the age appropriateness?
I think the issue and the reason that the Vonnegut estate is raising this lawsuit in Utah is that this book was being removed even from collections where it could be considered age appropriate. I think Slaughterhouse 5 arguably is a piece of literature that has educational value for certain levels of students within our public schools. So I think that's where the issue came in.
Representative Terry.
You mentioned states where laws have been enacted and plaintiffs have succeeded in court.
Yes.
I believe you also mentioned that there are other states that have statutes that are not as constitutionally vulnerable. Mm-hmm. Could you share those? Could you tell us where those states who they are?
I don't have a list off the top of my head. I know they talked about, I think Rhode Island passed some legislation this year. I know they were working on something in Maine. I think New Jersey's law might be another one that was modeled after the American Library Association formula. I'm happy to provide that information to the committee if it would be helpful. It's something I could email out to you guys tomorrow if it would be useful while you're discussing this legislation.
Sure.
Awesome. Okay. I'm happy to do that.
Any other questions? Seeing none, thank you very much.
Thank you.
Aubrey Friedman.
Madam Chair, committee members, Aubrey Friedman, live in Bridgewater. Speak in support of this bill. I want to concentrate on 2 specific incidents regarding this issue. And I totally support having a policy in place for parents to challenge books. So this was in the Newfound, a rural district. So that will be relevant in a second. So we had in 2022, there was a big, they got a new curriculum and there was some iffy stuff in there. And some parents or taxpayers noticed, and I've got examples in the backup that I'll pass out. Anyway, it was a big controversy, and it was actually a big embarrassment for this school district. They didn't vet the books properly. So in the end, they formed a curriculum committee to study this stuff. And actually parents, and I was one of our taxpayers, we went through all like grades, and we're talking like, this was elementary school. There was really some with sexual overtones. So we went through all the books ourselves, actually all the curriculum, the math, the English and everything. Okay, then a couple years later, we had the situation with the typical, books that are banned, the 10 most banned, the library book culture war issue. And here's how it worked out in Newfound. They have a policy which is rather similar to what's being proposed in this bill. The form was filled out to challenge the book, goes to the superintendent. He formed a committee with teachers, and they had they read the books, studied them, and rendered their decision that the books were okay. These are not harmful and whatever. And then the taxpayers who complained, they challenged that. We don't accept this verdict. So I went to the school board. The school board had a very robust discussion, I can tell you. Think about how most school boards lean which way politically. And so it was a 5-2 type of mix, and that was the decision. But it was a very robust discussion. In the end, the school board voted to, the books are okay, they're going to stay here. So it had a hearing. The liberal people on the liberal side were happy. It's freedom of speech, it's the First Amendment, all this stuff. The conservative people, they obviously weren't happy, but it went through the process. And there was as I say, a robust discussion. And as it turns out afterwards, the books did go back into the library, but they were not displaying them. They're kind of like, if you have to ask for them, but they'll be there. So it was kind of, I think it was a good way to handle it because it's a culture war issue and there's no way you're going to have everybody happy. And having the process play out, I think, worked out quite well. And even the conservative people in the end said, well, at least they're not displaying them, and we brought the issue. Okay, and I support it. Thank you.
Are there any questions? Representative Woodcock.
Thank you. Mr. Friedman, good to see you again. If local school boards already have a current policy that works with community standards and community members, and as you were indicating in your example you just gave, and there's a resolution, whichever way it happens to be, what's wrong with that?
Well, that particular one worked, I think, pretty fair for everybody, but I don't know that every school district has that. Actually,
they all have policies on that.
Well, I looked at my own policy for my school district, where I'm in Pasquaney now, and it actually says for, specific course material. So that to me is more about curriculum, to be honest. It's not the library books and the culture war stuff. So it doesn't really cover that. And this bill does. This is more broad. In a way, it's better. And it really does say specific course material. So then it to me is not broad enough.
Okay. Thank you. Thank you, Madam Chair.
Any other questions? Seeing none, thank you very much.
Thank you.
Sarah Terrell?
She said she had to leave and she left her testimony. It's written testimony, it's been distributed, but she had to leave.
Okay.
Is this?
Grizzlies Glenn?
It's Grisali.
Oh, thank
you. My name is Grisali. I'm from Manchester, and I'm a parent, and I'm here in opposition to this bill. The bill's being framed, to me, it's being framed as some type of parental right that we have but the language does not appear in that text. What this bill creates is not a right, it's a mechanism, and that distinction makes a difference. This bill establishes a formal, multi-step complaint and review process that allows materials in schools, including books, lessons, displays, guest speakers, to be challenged, investigated, escalated to the school board, and entered into the public record. It also imports the definition of harmful to minors from RSA 571B1, a statute specifically designed to address explicit sexual material under a narrow legal standard. That standard requires that material meet multiple criteria, including appealing to prudent interest and lacking serious value. This bill does not apply that definition narrowly. It extends it across the full scope of educational materials, while also introducing undefined and subjective terms such as age inappropriate and otherwise offensive. That combination does not create clarity. It creates interpretation. And when interpretation is placed inside a formal process that requires investigation, response, escalation, and public documentation, it does more than allow complaints. It increases their impact. This bill makes it easy for a single complaint to trigger a structured chain of action. And that raises a fundamental question, because it is notably easy in this context to create a system where a complaint results in a mandatory review, escalation, and a public accountability. And yet, we do not see the same level of urgency to establish equally structured enforceable mechanisms when it comes to reviewing the conduct of those who hold actual authority and power over others. Here, the threshold is low, the process is defined, and the response is required. In other contexts, the same clarity and enforceability is far less common. That contrast is not insignificant. Within schools, the outcome of this structure is predictable. When decision-making is tied to the formal complaint process with escalation and public exposure, the pressure is not toward inclusion. It is toward avoidance. Material is evaluated not only on its value, but on its vulnerability to challenge. As a parent, I do not want my child's education shaped by a system that lowers that threshold for the other restrictions while broadening the scope of what can be challenged. I do not want a legal standard that's designed for a completely different bill for explicit sexual material extended to a general education decision-making. And I do not want access to information narrowed through a process that rewards the persistence over expertise. Public education exists within a diverse society. It cannot function if the standard becomes whatever is least likely to be challenged. That is not protection, that is limitation. This bill does not create balance. It creates a mechanism that shifts control, expands pressure, and narrows access. And for these reasons, I respectfully urge you to oppose this bill. Thank you.
Are there any questions?
I just wanted to, it was Penn America, he was right. And I just wanted to read this statistics that it says here. It says during the 2023-2024 school year, 36% of all banned titles featured characters or people of color, and a quarter of them included LGBTQ people or characters. Erasure of identities is even clearer with certain types of books. 73% of all graphic and illustrated titles feature LGBTQ and representation people or characters of color, or discuss race or racism. And for all the inflammatory rhetoric about explicit books, only 13% of banned titles had on the page descriptions of sexual experiences. Thank you.
Thank you. Any questions? Representative Seller?
Thank you so much. When you have an opportunity later to just send us the link that you just read, that would be fantastic. Thank you.
Thank you very much.
Thank you.
Barrett Christina?
Thank you, Madam Chair. Good afternoon, members of the committee. Barrett Christina, New Hampshire School Boards Association. We are opposed to House Senate Bill 434. I do want to be clear, though, just as NHSBA has said with the multitude of other bills that have come across this committee the last 3 or 4 years, we don't oppose a bill requiring school boards to have a policy about reconsideration of instructional or materials that are in the library or otherwise available. We oppose primarily to the prescriptive nature of this bill. We've heard time and time again that it's a process bill, I'll note that over the number of bills that we've had, again, in both chambers the last 3 or 4 years, people who have wanted these sorts of bills have not come complaining about process. They've come complaining about the sorts of types of materials, about whether or not it's inappropriate, pornographic, age inappropriate. That's been the concern of the people that have come in favor of these bills the last number of years, not process. Also, the last number of years, we've had challenges in New Hampshire schools. Concord Monitor, December 2nd, 2025, Merrimack Valley School recommends removal of book from English class. Union Leader, March 22nd, 2023, Bow High School rejects parental challenges to a novel. NH Public Radio, November 3rd, 2023, Dover School Board unanimously rejects effort to ban a particular book from the library. Also important to note, the Dover challenge initially included 8 books that were specifically challenged. When I get to the bill a little bit earlier, we talk about some of the timelines. Challenging 8 books all at once may not be reasonable within the 25-day timeline that we have in the bill. An article from the School Library Journal of October 2010, New Hampshire parent challenges the Hunger Games, that came out of Goffstown. The Patch, which I guess is sort of a newspapery website, March 2024, 18 titles challenged in book bans in New Hampshire between 2020 and 2023. There were challenges to certain books in Litchfield in 2009. There was a challenge to a book in Bedford in fall of 2021. The processes that we have seem to be working in these particular communities. We don't need a bill establishing a unified process statewide when the processes are working in these communities that have been reported on where these challenges have been coming. Other aspects relative to the bill itself. There were discussions earlier about the definition of material. We agree that it's rather broad. And if you look at the broad definition of material in the bill, but then look at the rest of the statute about the complaint process and the review process, this is talking about dances or other representations perhaps performed by guests or speakers. So you have a guest speaker who does his or her best Elvis impression, shakes his hips, somebody in the audience finds that offensive, complains to the superintendent or the school board. We have to go through a process to remove that material from the school. As the bill says, that part doesn't make any sense. We think narrowing the definition to books, materials, pamphlets, magazines, movies, whatnot, we think would be more appropriate. Continuing on, I'm on page 1, line 15, where it says the material is harmful to minors, age appropriate. I'm going to focus on that. The educational
You'll
term.
need to wrap up because your time is up.
Okay, certainly. One last quick point about age appropriate, if that'd be all right. The Department of Education in their DOE rules 306.08 uses the phrase developmentally appropriate. The local school board shall require that each school provides a developmentally appropriate collection of resources aligned in all learning and grade levels, including online and print materials, equipment, technology, so on and so forth. So developmentally appropriate would be consistent with the minimum standards that were recently adopted by the State Board of Education. And that phrase is used maybe 2 or 3 other times, and it's actually specifically defined in the minimum standards as well too. Thank you, Madam Chair. I know I was had to limit the time period, but I'm happy to answer any questions if anybody has any.
Thank you. Representative Cornell.
Thank you. Thank you, Madam Chair. Thank you for taking my question. You mentioned a number of places that there had been requests to look at books. So, and they were all different places. Are there many school districts in New Hampshire that do not have a policy in place?
Thank you for the question, Representative. We don't track what school boards have what policies. We have 160 members that are, members of NHSBA. We can't track, each school board may have 200 or 300 policies. We can't track that. However, I will say that I forget if it was last year, all these bills kind of run together. I think it may have been 2 sessions ago when we had a bill seeking to limit or at least allow a process for parents to raise concerns about the materials in the school. I think there were 20 people on House at that time, and I went through each of the members on the board, and I found you remember, Representative, I found the policies from I think about 15 or 16 of the high schools that were representative on when it was just House Ed policy back a session or 2 sessions ago when I did that. So I think at this point, most school districts that at least have a high school will have a policy on reconsideration of certain materials. If you're a K through 6 school district, maybe you're not. Maybe it's more of an informal process. There may be a policy, but it's not going to be filled with deadlines and things of that nature.
Representative Wilcock.
Yeah, sure. Thank you, Attorney, for Christina, for taking a couple questions. When you just mentioned a moment ago about DOE being developmentally appropriate versus inappropriate, age inappropriate, was that our DOE here or is that federal?
No, that's the New Hampshire Department of Education. Again, it's in the 306 rules.
Okay.
The first one was ED Department of Education Rule 306.08. And then there's a definition, if I can find it as well, too. This is 306.01 K as in kangaroo. There's a definition. Developmentally appropriate means activities, materials, and environments that are suitable for a person's age, level of maturity, and stage of development, including cognitive, emotional, social, and physical abilities. Again, 306.01 K.
Thank you.
Yeah.
Just a follow-up, Madam Chair? Sure. Thank you. I asked a couple of times, I haven't got clarity. Hopefully you can give it to me. What does otherwise offensive mean?
Yeah, it's a subjective standard. You're not going to be able to, to some degree, it's sort of, what does reasonableness mean? Well, reasonableness means what 12 people on a jury decide it means in terms of behavior. So, what one person may find objectionable, another person may not find objectionable. That's why we have that provision. I think it's in RSA 18611 that allows for parents to opt their children out of course material. This is, we're talking more about library material for this bill, but course material that the parents find objectionable, and that's a subjective standard based on whatever the parents believe it to be.
Okay, thank you. Thank you, Madam Chair.
Representative Selig.
Thank you, and thank you for taking my question. You referenced that in Dover, for example, someone had challenged 8 books simultaneously, and in some of the other districts, I started losing track of the numbers, both long day and reason why I taught English and not math. But if we have, let's say, 3 different parents that each decide to challenge 20 books in September, how is the superintendent, or how do you see that working the way this bill is written, with the superintendent being able to investigate all, I've lost track of how many books I've gotten to at this point.
60.
Okay, thank you. See, it's a good thing you're paying attention. And manage that as well as their, superintendent job.
Right. So thank you for the question, Representative. It's not in the bill, but I'll tell you anecdotally, in some or many of the school districts where these challenges have arisen, the board has or maybe the superintendent has constituted a committee where you'll have maybe, let's say the book is in the middle school. You may have a middle school teacher, a high school teacher, a board member or two, the building level principal. I've heard, not in New Hampshire, but I've read articles nationwide where the board or the administration will invite in like a child psychologist to offer their opinion on whether or not it's age or developmentally appropriate. So, the timeline that's in the bill, notify parents within 10 days of receipt of the complaint, within 25 days of notice of receipt, or otherwise agreed by the parties. They make a determination within 5 days, you let the parents know. Yeah, if it's 1 or 2 books that are being challenged, I think the timeline is generally workable. But 8 books, asking people, who reads 8 books in a year, let alone 8 books in a month? I'm just saying. Some of us do and some of us don't. You know, and it's not just reading the book, you know, it's not, if you're reading it for the purpose of making a recommendation to a school board or an administration, you're not just reading it for pleasure, you know, you're reading it to do some in-depth analysis or really contemplate, is this okay for 7th graders or should we move it up to the high school? Is this okay not at all in any school? So that's our concern with sort of the tight timeline. I mean, I understand, you know, it says or otherwise agreed upon by both parties, and Senator Lang touched on that a little bit. He said, well, if the parent agrees to extend the deadline, all was well and good. Well, there's a second half to that equation as well, too, that remains unanswered.
Follow-up? Thank you. Thank you, and thank you for taking my follow-up. With books that may or may not be challenged, would you see, based on the way this bill is written, is there a distinction between books that are used within a classroom for the purposes of instruction versus books that are in a library, especially like if you think of a K-8 school where you might have the library sectioned out for early readers versus middle readers, et cetera. Is there anything in this bill that's going to make a distinction so that something that, you know, might not be, like I probably wouldn't give Fahrenheit 451 to my kindergartners, but I certainly use it at my high school level. Is there anything that distinguishes that in a library setting in this bill, or is it just subject to the exact same policy?
Thank you for the question, Representative. As I'm reading this, I think it would be inclusive of materials that are in the classroom for instructional purposes, and as well as materials that are in the library that are not part of curriculum or instruction, but rather the students could take out. And I'm looking at the definition of material means, so on and so forth, line 9, that are provided by the school district. I think that broad enough, or to not broad enough, but it would also encompass curricular material and additional resources that are found in the library. Thank you.
Representative Dry?
Thank you. Thank you for taking my question. Do you have a problem with the expansive list that defines materials?
I'm sorry, Representative, the list that defines materials.
The definition in this.
I mean, it's a little, you know, the figure, statues, dances, and representations. I mean, seems a little peculiar. And also, you know, employees, obviously, volunteers, sure, the guests or speakers, I don't think is necessary because, you know, again, the remainder of the bill talks about a process to remove the material from the school. If it's a guest speaker that is inappropriate for whatever reason, curses, gives the finger, you know, whatever the case may be, you know, we're not going to let that person back into school again. I don't think we need to go to a process of 25 days and notify the parents if it's that blatantly, you know, inappropriate. And that was, I mean, you know, that may be, you know, I don't like going down the road of, we can all think of crazy hypotheticals, right? And we don't need to spend our time doing that. But if you were to just to limit it to, and when one of the bills in the last couple of years, I gave an amendment to, I had a definition of materials. I don't remember what it was offhand. I know it was not this expansive. If you want, I can try and get that to you as well, too. I think it may have been on House Bill, was it Senate Bill 324, House Bill 324 last year? But I think it's a little more broad than it needs to be, but it's not that far off.
A follow-up. Because I'm looking at the chapter 650 in the criminal code and obscene matter, and it just has basically word for word materials for this.
I'm sorry, Representative, where were you looking at that again?
Title 62 criminal code, chapter 650 obscene matter.
I was looking for that statute earlier, 650. I mean, if the definition within this bill is consistent with the definition of obscene matter in RSA 650, and it's similar. I think this is broader, though. I think this is more expansive.
I disagree, but you can take a look at it side by side.
Sure. Yeah, that's fine. And I'm sorry, I don't mean to interrupt. I may have used that definition in one of the proposed amendments I gave at one of the bills the last couple of years, so we may not be that far off.
Thank you. Representative Terry?
Yeah, I think the more that I'm hearing, the more I think the answer is going to be no, but I will ask you anyway. With this being such a hot button issue, and it didn't just arise within the last year or two, Has your association ever developed any model policies in response to the issue and/or requests from school boards for assistance throughout the state, or made available model policies from other associations across the country?
Thank you for the question, Representative. The answer is actually yes. We do have a sample policy. We have not updated that in a number of years. It's perhaps a little thin. It does not outline a timeline or process per se. But when these challenges first started arising in 2020, 21, 22, rather than amending our sample policy and sending that out statewide, recognizing that different boards may want different processes, we certainly did some research. I reached out to other state school boards associations and basically culled resources, articles, white papers, sample policies from across the country and provided those to our members to develop their own local policies.
Follow-up?
Could you make that available to us?
Absolutely. I'll go through my files, see what I can find.
Thank you.
Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. We've gone through like some of the specifics in the bill. Is there anything that hasn't been brought up in the actual language of the bill that you could clarify in terms of how it may or may not work?
Yeah, thank you for the question, Representative. We talked about the definition of material, talked about sort of the age-appropriate language versus developmentally appropriate language. The 25 days back on the bottom of page 1, line 29, I think I talked about that with respect to, Dover having 19 or 18 book challenges. Talked about none of the testimony at any of the hearings over the last number of years have complained about the process per se. I'm just going through my notes. I think that's about it, at least in terms of the bill itself, aside from some of the broader policy aspects that I talked about. Thank you.
Representative Woodcock.
Thank you. And this should conclude my questions. I think I've heard almost all of it. I was going back to material, and from books that we've expanded 19 different categories here, or 18 if I count, who knows by web, it's not going to be huge, but 19 more categories. I want to go back, and you mentioned with Elvis and the shaking hips, but I'm thinking about those pieces like presentations and guest speakers, things that may come in the classroom, maybe an audience for a high school audience, those people. That prohibition to withdraw, it's already happened. And I find I'm reading this, I'm saying like two things. This is, we're taking this out for the future, but then as you read some of this, it's for items that already happened in the school, and you say, well, we're going to ban it. Well, you can't ban it because it already happened.
Right.
So it makes me wonder, is this going to be one step of going back to from now on, everything has to be checked, evaluated, okay by someone before they can do anything in the classroom?
Right.
I mean, I see this, am I missing that?
Yeah, no, thank you for the question, Representative Woodcock. What I think would perhaps be more clarifying, as opposed to the guest speaker who does something inappropriate, then, we can ban that person from coming back, but the incident has already happened, so to speak, would be to limit the definition of materials to physical material, and I guess digital as well too, since books on Kindles and we've talked about the Sora app before. But if we were to limit it to, I'm going to call it physical material for the sake of my answer here, but rather than people, if you will. Okay. And I guess physical material could also include, posters and signs and statutes and whatever the case may be.
Okay. Thank you. Thank you, Madam Chair.
Mm-hmm. Any other questions? Seeing none, thank you. Sorry. Representative Litchfield.
Thank you, Madam Chair, and thank you, Attorney Christina. I'm going to ask you a couple questions. One I should probably already know, but my computer's stumped. So right now in New Hampshire statute, do you know if we're required to notify parents ahead of time if a guest speaker is coming in?
It's a good question. Offhand, I don't know if there is any specific affirmative requirement to do that. I don't think so.
And I say that only because a couple of reasons. One, I'm super disappointed that nobody has brought up the fact when we're talking about what's objectionable or obscene. Nobody quoted Supreme Court Justice Potter Stewart I know it when I see it because it's classic, and he's probably rolling in his grave right now, right? Because he did not want to be known for that, right? But I want to say too that when it comes to the speakers, I did have a situation in a school where I was alerted ahead of time of a speaker's local author, but when I had the chance to look up the book, I kept my child back home because it was for middle school 11-year-olds to 14-year-olds, and the book was about their only book, a young lady that got drunk, spent the night in a sports team, took advantage of her. She woke up nude and Sharpie, their names were in Sharpie all over her body. This is what's being shown to our children. My question to you is, wouldn't it make sense for us to be consistent with, even if this is not perfect, and I know you've had everyone that's testified today has had some great suggestions for us, wouldn't it make sense for us to have a consistent policy across the state though?
Thank you for the question, Representative. I know Representative Terry, you asked that a little bit as well too. What I would say is school districts have different processes for all sorts of things. The process for enrolling in kindergarten is different in one district than it is in a different district. The process for signing up for the basketball team is different in one district than it is for a different district. The process for student discipline is going to be different in one district than it is in a neighboring district. So, I understand, your legislators, you make laws impacting statewide, and I understand there may be a desire to have uniformity and consistency with a policy like this statewide. Again, my response would be that, one, we value local control. We've talked about that numerous times, Representative. Our opinion is local school boards should be allowed to develop their own local policies to fit their own local needs. As I said, if you want a bill requiring a policy, no objection from NHSBA at all. And I guess the other aspect to that, I had a second thought that I was going to say to that, but I forget what it was, but I'll let it go. I had another point, but it fell out of my head. So thank you, Representative. Yep.
Any other questions? Seeing none, thank you very much. Brian Hawkins? Just
bear with the last one, that's all.
no.
Yeah, it does feel cool for this room. Thank you, Madam Chair. For the record, Brian Hawkins, representing NEA New Hampshire, here in opposition to Senate Bill 434. Not to repeat the testimony on the last bill, but I think a lot of what I have in my written testimony and in my testimony has been stated. So I'll just hit those couple of points. Certainly, school districts, it is a good idea to have a reconsideration policy for school materials, and I think all of the school districts, in the quick look, certainly on the Senate Education Committee, but also on this committee, have policies, and so I don't think we want to. I don't think there's any reason to override some of those policies, those reconsideration policies. It was raised earlier about the subjective nature of terms that are undefined, like what is offensive, or there are a lot of things that can offend people, and so that's very broad. And then finally, it was raised about some of the specific processes themselves, a concern we'd have about the prescribing the timelines here. I think it's important to make sure that especially if it's a parent, they have some idea of, timeliness of their complaint being addressed. That's important. But it would, our concern would be, we want to make sure that, for especially for some small school districts that are, resource strapped, or if there was a large number of materials being challenged, that it can accommodate for that. Also, some school board policies, and I'm thinking of ones like, I think, I know Salem, Claremont, several. I'm going back to the Senate Education Committee. I apologize, but those consider bringing a team that is in the school to review. So it's not just one single individual, because in a previous iteration of this bill, when Senator Lang mentioned the principal, that's a lot. This could be a lot to put on one principal. So, happy that they referenced a designee, but I think some of the timelines could be restrictive around trying to bring a group like that together. And then finally, I'll just, in response to one of the questions earlier from the veto of last year, the preference indicated in the veto indicated looking at the objectionable material statute. I think because that encompasses, being able to find an alternative for an individual parent's child, as opposed to potentially imposing one viewpoint on the entire school district. And so I wanted to just make reference to that. And with that, I will close my testimony and happy to take any questions. I do have written testimony I'll hand in.
Any questions for Brian? Representative Litchfield?
Thank you. Thank you for taking my question. Do you happen to know by any chance what the policy letters are? The sample policy letters are for I know you're not New Hampshire School Board Association, but it occurred to me that if many of the schools out there have a policy, they put it in the same place and they typically use the same letters, even if
I'm not sure.
I don't mean to put you on the spot.
That's okay.
We can bring Becky up. Okay. Okay.
Wait, we didn't even. Maybe he knows, and I did.
That would be excellent for a trivia night, I'm sure, if I knew that.
So he's saying thank you.
I don't recall when looking at the individual some of the individual policies that I referenced. I don't recall whether there was a common letter designation.
Okay.
So
thank you.
Yeah.
Any other questions? Representative Selig?
Thank you so much. I'm just going back to that list of materials and all the different things that are provided by the school district, and thinking about taking kids on a field trip as a teacher. So the field trip is provided by the school district, and we go to a museum where there might be nude figures because it's a museum. The way you read this bill, would that, how would that fit in? Like, would they be able to object to having field trips to this museum? Is that going to block people's ability to study these things?
Well, I think that's why during Mr. Christina's testimony, we talked a little bit about the issue with the speakers coming to the school, that they're not necessarily repeat instances, as opposed to a book or a printed material. I do think any printed matter is very broad still, though. So, but in any instance, I know from even my personal, if a student is going on a field trip, there's a notice that goes out about that. There's a permission slip several permission slips that need to be signed in some cases. I know because my daughter makes sure that I have done that before she leaves for school in the morning. And so I think there are opportunities to either raise concerns about a situation like that, or to opt out of it.
Representative Drake?
Thank you very much, and thank you for taking my question. To follow up on that, though, wouldn't you agree that the obscene material also gives places where this material is used in ways that the material is used that makes it obscene? There's like 4 or 5 of them
in the obscenity statute.
So should be taken in consideration with the rest of the statute, is my question.
Oh, I'm sorry. That in the case of, say, for example, going to a museum, correct. I believe, and I could be wrong, but I believe there is a provision in there about taking into account literary value and so forth. So I would imagine that would play into it.
Thank you.
Hopefully I'm answering your question. Okay.
Any other questions? Seeing none, thank you very much.
Thank you.
That's okay. Yep. Deb is next.
Okay, I'm sorry. There are two policies, IGE, which is parental objection to specific course material, and IHAM, and IHAMR, which is an additional form, but health education and exemption from instruction, as well as objectionable course material opt-out forms.
Thank you very much. Oh. Can you,
I apologize. I didn't even introduce myself because I thought I was just saying two things and then getting up. I apologize.
And because of me, you have to do a pink card. I'm sorry.
That's quite all right,
So
Representative.
it could be kind of a rhetorical question. Thank you for taking my question. I'm just trying to look it up right now. These two policies or three policies that you just mentioned, they are specific to an individual child or student, being opted out. This is not the material being removed from the school, correct?
Thank you for the question, Representative Litchfield. Yes, those are the priority and required by law policies that states that, yes, the board recognizes there may be course materials which parents and guardians find objectionable, and this is the way in which they can find alternative activities for their child to do during that time and opt them out of those things. There's a general policy about that. That is the IGE policy. The other policy that I mentioned is specific to the health and sexual education curriculum opt-outs as well. However, the opting out forms could be used for both issues.
Thank you.
Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. When I was looking up the policies, I also noted that there was a policy related to public concerns and complaints about instructional resources called KEC. Would that also be relevant
to that section of our sample policies?
Yeah. Thank you.
You're welcome. KEC, yes, reconsideration of instructional materials, and KEB is about public complaints for specifically to personnel, employees, etc. But they would go together. But reconsideration of instructional materials is KEC.
Any other questions? Seeing none, thank you very much.
Fill out a pink card. I apologize to Ms. Howes, who I believe was waiting next.
Deborah House?
Let's see, this is on. Great. Good afternoon, Madam Chair, members of the Education Policy Committee. I'm up here for the first time today. My name is Deborah Howes. I'm president of the American Federation of Teachers, New Hampshire. We've got 3,500 educators and public employees across the state, mostly in pre-K through 12 public education. And I am here opposed to Senate Bill 434. We've heard a lot about how this is a process bill and how it gives parents the right to challenge materials and books in our public schools. And, certainly I think it should be easy for parents and guardians to understand if they want to challenge something. But I do not think a top-down, one-size-fits-all process as described in this bill is the right process, because what we haven't heard a lot about is students' rights. Under our Constitution, students have a right to a robust public school education, and as recognized by the United States Supreme Court, students have a right to access a wide variety of materials in their schools and in their school libraries. And this process, as it's outlined, will get in the way of that. So that is my main concern, is the process as described does not balance those rights appropriately. And why adopt a process that's going to be challenged and isn't going to protect the rights of everyone who the process would cover? So as described, it has some pretty vague standards in it. We're talking about material that a complainant describes as offensive or age inappropriate, and that is very subjective. It is going to differ from one person to another. It does refer to harmful to minors and refers to another section of law. But, looking at that, many people misunderstand that harmful to minors section of the law requires the material to appeal to prurient interest, depict sexual conduct, and lack serious value, and have to be considered as a whole. So not just the most shocking scene or most shocking page or two of a book. You've got to look at the whole thing. When people misuse that, they might think something is harmful to minors or pornographic when it's not. You've got to look at the work as a whole. Nowhere in this bill does it require that the challenged material or book be considered as a whole. So that's one major concern I have about it. It places tight timelines on principals or superintendents, whoever it is you're envisioning is the one receiving the complaint and having to act on it. It does say superintendent. I know earlier discussions had talked about the principal being closer to the school. That's very hard to respond to because both of those people have a lot of responsibilities already in our education system. You've got 10 days to either read a whole book, consider it, whether it's got any educational value to students, discuss it with educators who would know, maybe convene a committee on it, and then decide whether it has value or fails this harmful to minors test, which is based on a different Supreme Court decision, by the way, U.S. Supreme Court. So there's something to this. There's validity behind it. It makes it easy for a complainant to pressure schools into removing books. So it is indeed a book and material mechanism that makes it easy to get stuff removed, makes our students' educational environment less challenging, less full of ideas that may be entirely appropriate for them to encounter. You might want to discuss what age that's appropriate at, but this doesn't balance their needs and their rights with the complainant's rights. Another concern about this, nowhere in here does it say the complaint, the nature of it, that something's being challenged has to be made public at any point before the appeal to the school board. So if you think something really should be in the school and someone else finds it offensive, you don't know about it until after it's already gone, after that whole decision process has been gone through. So we don't have to necessarily look at the work as a whole. We don't have to necessarily have a committee. It could be one person making the decision. There's a lot of holes in this, and it's not going to pass a constitutional review because you're not balancing the rights of everyone. So I have written testimony prepared, and you will get a chance to read it. I'm probably running out of time. But yeah, when our students lose access to diverse and challenging text, they lose opportunities. So for the rights of our students and the rights of our educators, I'm urging you to ITL this bill.
So I do agree with you about the taking it as a whole. I think it's really important to set a very high bar when you're reconsidering books. I think, so SB33 had that language in it. Everything that you said was in SB33. It set a very high bar. It would have made that decision objective rather than subjective. But I believe you oppose that too, so. Is there any?
I would have to go back and look and see what concerns I had about that. I think it also did not meet some of the constitutional challenges, but this certainly doesn't. The timelines are too tight, the pressure is too high, and there's nothing that protects mostly the students, but also the educators from feeling the pressure to not choose anything that might elicit objections. So it leads to that self-censorship. Should I put that poster up on the wall or is someone going to complain? Should I choose this book for my classroom library or is someone going to complain? If we self-censor to avoid complaints, students' educational opportunities get poorer and they're the worse off for it. Thank you.
Any
That's really my point. Yeah.
Representative Litchfield?
Thank you. Thank you for taking my question. I'm curious if you've seen many of the books that have been challenged right here in the state of New Hampshire. I have probably a dozen of them that I've ordered at home, but they are very graphic, because they're graphic novels, very graphic pictures of, there's one where there are several men having sex with one woman. There is someone giving oral sex or someone ejaculating into a tiny water bottle. I mean, that's just the tip of the iceberg. Have you seen any of these books? And if not, I'm happy to share if you're willing to see them. And I mean that in a respectful way, because I want you to share with me, and I want to be able to share with you.
So we're back to harmful to minors or the Miller test, and it's a three-pronged test. So, you know, if we're evaluating things, we have to look at prurient interests depicting sexual acts and lacking serious value. So you would have to consider the work as a whole. And these graphic novels certainly would not be something you would want at your elementary school or your middle school, but they may be appropriate at your high school for some students in your high school, because they may be appropriate in your high school library as a book of choice for some students to read. That is a choice that some parents say they are fine with their children reading. Why should you decide that for every other parent and every other child? Why should I decide it?
Well, I just think it's taxpayers paying for it. But that being said, we agree to disagree. I'm just curious, would you be willing to work with us to improve this bill in a way that you're comfortable? Would you be willing to send us suggestions?
Dover has a very robust materials reconsideration policy that does involve forming a committee where they've got educators on it, and there is a chance for public input to it. That kind of process where people know what's being challenged and when there's going to be time to read it and people have a chance to give their opinion on it would be much more appropriate and would pass constitutional muster. So that would be a much better model than what we see outlined here, with its tight timelines and its pressure to remove things because of one person's opinion who finds it offensive.
Is that what you had sent to us earlier, or was that something?
No, earlier I sent a court opinion because I heard questions asked about what the status was of the court opinion on the overturned divisive concept law.
So would you send the model policy, please?
I can get the Dover policy and send it to you, yes.
Thank you.
You're welcome.
Any other questions? Seeing none, thank you very much. With that, we'll close the hearing.
You guys got a PDF earlier?